My dear friends in legal profession and my fellow citizens, brothers and sisters, I would like to speak on the present controversy relating to the functioning of the judiciary, social diversity, independence, and the constitutional promise, higher judiciary at the crossroads. My friends, the Indian judiciary was envisaged by Baba Sahib Dr. B.R. Ambedkar, the architect of the Indian Constitution, as the ultimate guardian of the Constitution and most vital counter-majoritarian institution in the Republic. In a society marked by a deep social inequalities, Ambedkar believed that the courts must stand firm against tyranny of numbers, executive excesses, and political prejudice. Baba Sahib Ambedkar viewed the Indian judiciary as the essential independent custodian of the Constitution and the citizens' rights, designed to act as a check against the executive and legislative tyranny. He emphasized an independent, non-political judiciary, famously calling Article 32, that is the constitutional remedies. Article 32 is the soul of the Constitution. He championed the power of judicial review to strike down laws that violate the Constitution, reinforcing its supremacy. His vision aimed at building a robust legal framework that guaranteed justice, liberty, and equality by empowering courts to act as the ultimate safeguard of the Republic. Today, however, a growing sense of democratic anxiety surrounds the higher judiciary. Questions are being raised by citizens, lawyers, scholars, and even sitting judges about judicial independence, social representativeness, and the increasing perception that the constitutional adjudication is yielding space to the executive convenience and majoritarian ideology. Recent remarks by the Supreme Court Judge Honorable Justice Ujjal Bayan on judicial transfers, combined with official data revealing the lack of social diversity in judicial appointments, compel a serious national conversation. The issue is not about individual judges, but about the institutional direction of the judiciary itself. Baba Sahib Dr. B.R. Ambedkar consistently warned that democracy in India could not survive merely through elections or parliamentary majorities. He argued that the constitutional morality, not majoritarian will, must guide the institutions. The judiciary, therefore, was entrusted with the extraordinary responsibility to protect the fundamental rights, to restrain the executive power, and to give voice to those who excluded from the political power. Ambedkar also cautioned that a constitution, however progressive, could be rendered ineffective if institutions were captured by dominant social or political interests. Judicial independence in his vision was inseparable from social justice and equality. One of the most glaring contradictions in India's constitutional practice today is the poor social representation in the higher judiciary. Underrepresentation of SC, ST, OBCs and minorities in higher judiciary remains a concern. Unlike the reservation system in public employment and subordinate judiciary, there is no formal reservation in the higher judicial appointments. Most judges are selected from a pool of senior advocates and high court judges where upper caste and privileged groups dominate. Official data placed before the parliament by the central government itself reveals that nearly 3/4 of the high court judges appointed in recent years belong to upper caste category. As per the statistics furnished by the government in Lok Sabha, between 2018 and 2023, a total of 661 judges were appointed to the high courts, out of which 499 belong to upper caste and Brahmins. 78 are from OBCs, 21 are SCs, and 12 STs. Thus, judges from scheduled castes, scheduled tribes, and other backward classes and minority communities together constitute less than 1/4 of the higher judiciary. Women account only about 13 to 13 to 14% of the judges in the Supreme Court and High Courts combined. The latest data, the latest one now in the recent Parliament session, the latest data given by the Minister of State for Law and Justice Arjun Ram Meghawal in a written response to the question by Rajya Sabha MP P. Wilson on February 5th, 2026 in the Parliament, that nearly 3/4 of the judges appointed to the Supreme Court and High Courts between 1/1/2021 to 31/2026 belongs to upper caste. Out of 593 judges appointed to various high courts during the period, 157 belong to scheduled caste, scheduled tribes, other backward classes or minority communities, while the remaining appointments were from general upper caste category. In percentage terms, 26 SCs 4.38%, 14 scheduled tribes 2.36%, OBCs 80 members 13.49%, minorities 37 13.49%, and upper caste 436 73.52%. These figures stand in a stark contrast to India's social reality, where the SCs, STs, OBCs, minorities, and women together form the overwhelming majority of the population. This persistent imbalance is not accidental, my friends. It is structural. On the other hand, the district and subordinate judiciary in the country have 14.15% Dalits, 5.12 tribals, and 26.64% OBCs as judges, with statistics showing that the social diversity among them is higher in South India than North India. Thus, the lower judiciary is more representative compared to the High Courts and Supreme Court. A socially homogeneous judiciary risks interpreting laws through a narrow social lens. Issues of caste discrimination, minority rights, labor rights, land acquisition, state violence, and civil liberties are not abstract legal questions, my friends. They are lived realities for millions. When those realities are underrepresented on the bench, public faith in the impartial justice inevitably erodes. This is not a change against integrity of the individual, charge against the integrity of an individual judges. It is a constitutional critique of an appointment system that has failed to democratize access to judicial power. Executive influence and the politics of judicial transfers. My friends, concerns about judicial independence have been sharpened by the recent public observations of Justice Ujjwal Bhuyan, a sitting judge of the Supreme Court. He has openly expressed unease over the instances where judicial transfers appear to have been carried out at the behest of the central government, particularly involving judges whose decisions were perceived to be as inconvenient to those in power. Transfers have historically been used as a subtle instruments of control. Even when framed as administrative measures, they can function as signals, rewarding compliance and discouraging judicial courage. When the collegium appears to accommodate executive preferences, the damage is not merely procedural, my friends. It strikes at the moral authority of the judiciary. What is most disturbing is that these concerns are no longer voiced only by the critics outside the system, but by the judges from within. This signals a deeper institutional unease that cannot be dismissed lightly. India's constitution is deliberately a counter-majoritarian, my friends. Fundamental rights exist precisely to protect the minorities, dissenters, and marginalized sections from the excesses of the majority rule. Yet, there is growing perception that sections of the judiciary are increasingly deferential to the dominant political narratives. Delays in hearing crucial constitutional challenges, reluctance to intervene in cases involving misuse of the state power, and selective urgency in adjudication have fostered the belief that judicial restraint is sliding into judicial retreat. When courts appear hesitant to confront majoritarian excesses, constitutional democracy risks being reduced to mere electoral arithmetic. The rule of law cannot survive if it becomes indistinguishable from the rule by law. The collegium system was evolved to protect judicial independence from executive interference. While it has prevented overt political control, its opaque functioning has generated new problems: lack of transparency, limited accountability, and inadequate attention to social diversity. An institution that decides its own composition, my friends, that own composition behind closed doors without publicly articulated criteria cannot inspire confidence in a diverse democracy. Independence cannot be sustained by secrecy alone. My friends, what are the remedies to reclaim the constitutional path and independence of judiciary? That is, one is democratizing judicial appointments. Judicial appointments must be consciously reflect India's social diversity. Transparency, recorded reasons, and institutional commitment to inclusion are essential to restore public faith. Then protecting judges from executive retaliation. Clear conventions against punitive transfers and subtle coercion must be evolved and strictly followed. Then reaffirming constitutional morality. Courts must place the preamble, justice, liberty, equality, and fraternity at the center of constitutional interpretation, not political convenience. Strengthening institutional courage. Judicial independence cannot rest on individual bravery alone. It must be collectively asserted and institutionally defended. Role of citizens and civil society. My friends, ultimately, an alert bar, vigilant media, and informed citizens are indispensable to preserving judicial independence. Public scrutiny strengthens democracy. India's judiciary, my friends, now stands at a defining moment. It can either reclaim its historic role as a fearless guardian of the institution or risk the gradual erosion of its credibility. As Dr. Ambedkar warned, constitutional values do not enforce themselves, they depend on the integrity and courage of the institutions. The independence of the judiciary is not a privilege of judges, it is a fundamental right of the people. So, my friends, now I hope that the judiciary will reclaim its judicial independence. Thank you. Thank you very much.